A few words about the ECtHR Center for those of you who don't know us. We are a legal charity based in England, and we use the power of European law, that's both Council of Europe and European Union, to protect fundamental rights. So we provide free legal advice and representation to all of our people who contact us before domestic and European courts. And we engage what is known is very commonly known as strategic litigation. We call it impact-based litigation, just because we think strategic is a bit of an army-related or hostile term. We engage in training and capacity building, and we also engage in standard setting. We have been long working in the area of children's rights, and we have children as a golden thread running and as a priority running through many areas of our activities. So, for instance, we deal with asylum-seeking children, but also by other children in judicial or quasi-judicial proceedings. So, for instance, trafficked children or children in detention or in prison. So this was addressed in a specific project that some of you may have been involved in, which was called EU-Separated Children in Judicial Proceedings. What I'm going to do today is I'm going to highlight the recent jurisprudence of the European Court of Human Rights and bring to your attention cases pertaining to vulnerable asylum seekers and in particular children. I'm going to emphasize the importance of protections to vulnerable groups relating to minors. I'm going to track the development, highlight any developments in international norms and standard setting by the ECtHR in asylum law and minors. And I'm going to draw upon the need to develop better policies on child migration. So I'm going to try and focus your attention on potential missing pieces of the puzzle from the perspective of both case law, as well as we can talk about practice and future action that may need to be taken. As a means of introduction, I've included here a slide with some statistics drawn by UNICEF, showing the number of unaccompanied minors that have arrived in the countries of Greece, Italy, Spain. And what is notable about this slide, and it's not found in the information I've provided here, is the fact that 34% of the children who've arrived have been unaccompanied and separated. This is something highlighting their vulnerability, not just because of their migration situation, but mostly, and something that applies to everyone, because of their minority. They are all vulnerable because of them being underage, and that not only makes them vulnerable pertaining to their asylum situation, but vulnerable and open to a whole lot of other situations, such as, for instance, exploitation and human trafficking. I'm going to explore this issue by some themes. And the main theme is that we're going to see in all the cases is the inherent vulnerability of children. However, as we will see through the case law, the court in 2019 has added several other layers of vulnerability or other vulnerability factors that render the inherent vulnerability of children even more heightened. So, for instance, we will see cases about children in migration situation, cases about separated children, cases about children that were detained together with their adult parents, cases about children in detention or protective custody, cases about children placed in unsuitable detention conditions, cases about children who have been unidentified, and by this I mean children who have not been identified as children or were within age assessment proceedings, and cases where the state failed to take positive measures to provide protection in order to prevent further harm and provide the standards that these children were entitled to. So I'm going to start by diving straight into the cases. By starting with the case of JB and others versus Turkey. I do apologize for the small font, and I hope you're able to open the presentation on a full screen in order to be able to benefit fully from the slides. So the case is about the detention pending expulsion of a mother and her 3 children, who were all Russian nationals and were arrested pending attempting to cross the Syrian border and after entering Turkey. So this case, the family were transferred to the Kumkapi Removal Center, and in order for the mother's deportation was issued. The family sought international protection status, and they were transferred to another removal center. On 2015, the Gaziantep Magistrates Court ruled the detention of applicants unlawful, and the family were released 5 days later. However, the applicant submitted a complaint under Articles 3, 8, and 13 of the ECtHR that the material conditions in the Kumkapi and Gaziantep centers were unsuitable for the mental and physical health, particularly for the children, and that no effective remedy was available to raise these complaints. And to give you a little bit of context about the kind of material conditions that these individuals were subjected to, is that the children, first of all, were exposed to tobacco fumes because they were detained in a place where other applicants were smoking. Their room was infested with bed bugs and other insects that were biting the children. And when the authorities brought a disinfestation authority to disinfect the room, the children were made to stay in the room while the authorities disinfected the room. In terms of beds, the applicants were allocated a bunk bed, and the children were sleeping on the upper bunk bed one night, fell down and hit their head. And they were not given access to hospitals, apart from a case where they were one of the children had high fever and had to be transferred to the hospital immediately. No suitable food for the children was given apart from the applicants' lawyers. And this paints a particularly grim picture when it comes to these applicants. And also, interestingly here, another comment from me would be that we could draw some parallels between these conditions and the infection and this infestation and the lack of access to healthcare with some potential cases that may arise coming up due to COVID-19 situation pandemic and the situation in various hotspots around Greece. A complaint was also made regarding the lawfulness of their detention under Article 5, 1, 2, and 4. So what the court found in this particular scenario is that there was a violation of Article 3 due to the detention of children with reference to the material conditions in the detention center which were not appropriate for minors. And that was fair enough. The court reiterated the principle of human dignity, and of course it said that keeping children under these conditions, even for a short time, amounted to a violation of Article 31. The court also highlighted, this is something you may want to take a note on, the court highlighted Article 37 of the UNCRC and reiterated that extreme vulnerability of children, accompanied or not, and this is an important point, takes precedent over any consideration about their irregular migration status. And this is a very, very important point because the court did not distinguish that particular vulnerability between accompanied or unaccompanied minors. And in that particular case, we find that their children being accompanied by the mother, in fact, increased their vulnerability to detention, as we will see with regard to their complaint under Article 5.1. So, under 5.1, the court found that the applicants were not detained in accordance with the procedure described by law, as the detention order only mentioned the mother, yet the whole family was detained. And this is exactly what I mentioned earlier. The fact that the children in that particular case were accompanied increased their vulnerability to be exposed to the situation of detention. So we shouldn't have, as practitioners or as academics, in our minds the fact that a children being unaccompanied is necessarily the only case in which the vulnerability is heightened. With regards to paragraph 5.4, the court found a violation of the applicant's right under this article of the Convention on account of the failure of both the Istanbul Magistrates Court and the Constitutional Court to conduct a review of the lawfulness of the detention in an effective and speedy manner. And in particular, the court found that the country should have adopted alternative measures, not only as regards the children, but also as regards to their parents. As regards Article 13, which was used and claimed in conjunction with Article 13, Article 3 and 13 them together, as Thomas highlighted yesterday, the court found that there was a violation on account of the absence of effective remedies to complain about the conditions on detention. The court highlighted that the mental and emotional suffering of the children was enough to reach the threshold to qualify for a violation of this article. And perhaps something to consider there is that to what extent would this case apply to an open reception center area and lack of sanitization or lack of review of condition of detention, if there's a violation regarding the freedom of movement of the persons within by the state. So some additional notes about this case to consider and why we put it first is that because the court notes that the move in international law towards adopting alternative measures to the administrative detention of migrants appears to concern not only children but also their parents. So parents and children alike should be considered when the state considers alternative measures to the administrative detention. The court also notes that various international bodies, including the Council of Europe, are increasingly calling on states to expeditiously and completely seize or eradicate the immigration detention of children. And the court particularly noted, this is something that is not on the slide, that the protection of the best interest of the child involves helping families stay together and detention be used only as a measure of last resort. So again, a case against Turkey, which may have multiple implications for the current cases that may now be in development within the pandemic. The next case that I'd like to talk to you about is the case of SHD and others versus Greece and a number of other countries. This was a case, again, that was published in 2019. It's a chamber judgment, and it concerns 5 unaccompanied children of Afghan origin that arrived in Greece in early 2016. During their time in Greece, they were subjected to situations of detention and arrest, whilst being in between finding shelter at camps or with no other means. Under Article 3, they complained their conditions of detention within the Greek police stations and during their stay at the Idomeni camp, and under Article 5.1 regarding the protective custody regime that they were held under in police station. So what the court did regarding Article 3 is that, first of all, reiterated that detention of children, even for short periods of time, amounts to a violation of Article 3. And it found indeed that the detention of applicants within the Polikastro and Filatea police station was treatment against Article 3. Why did the court find that? Because it found that the conditions in police stations can create the feeling of isolation and can negatively affect physical and mental well-being. What the court actually heard to get to this statement is that the children were isolated and anxious, and their mental being was at risk. It held, though, it was very, very interesting regarding Article 3 that the court linked the positive obligation of the state in protecting and bearing responsibility of the unaccompanied children under Article 3 and Article 20 of the UNCRC, to which in this case extended itself to one of the camps which was not under the control of the state authorities. And what the court heard in order to hold this particular finding is that the Idomeni camp, in the Idomeni camp, the children were not detained. It was an open camp which was not run by state authorities. So despite the camp not being run by the state, the court thought that the state had a positive obligation to protect the children under Article 3 and Article 20 and to provide alternative care for the children deprived from care of within their family environment. The conditions within the Idomeni camp were not found suitable for young children, and authorities, the court found, had failed to take charge of the applicants and protect them and protect their rights in view of their particular vulnerability on account of their age. So again, this is an important judgment because the court talked about the Idomeni camp, which was a reality in Greece for an extended period of time during the peak of the migration situation starting in 2015. With regards to the complaint of the applicants in Article 5.1, the court held that the protective custody of 3 of the applicants in police stations amounted to a deprivation of liberty. The court found in particular that protective custody in Greek law under the Presidential Decree 141 of 1991 is not designed for unaccompanied migrant minors and does not set a time limit. Especially the absence of time limit has found to be enough in order to amount to a violation of that particular article. And the court highlighted that the detention of applicants was unlawful in relation to Article 3 of the UNCRC and the Asylum Procedures Directive. Again, this is another case that the court takes into account the provisions of the UNCRC, and this was also something to be noted. Some additional pointers regarding this case that you may want to take away is that the court, when examining the applicant's complaints under Article 3, referenced reports from the CPT committees, committee that affirmed detention of unaccompanied or separated minors without psychological or social support is unacceptable. It also urged the state to proceed to prompt identification of unaccompanied and separated children in order to provide the necessary support. even if applications for asylum are intended for elsewhere. Again, the urge for identification builds upon the state obligations in order to provide protection for minors in migratory situations. The next case that I'd like to run through with you is the case of HA and others versus Greece. Again, a country against Greece concerning 9 unaccompanied children who shortly after crossing Greece's borders, they had been placed under protective custody in police stations in northern Greece. They were living in the police station in the Dagyavata Center, and they complained about the absence of an effective remedy about these conditions and how this amounted to a violation of Article 3 and 13. Invoking Article 3, the claimants also alleged to have been subjected to ill treatment by the police officers, and they also complained about the lack of effective investigation into their allegations of ill treatment by the police. Relying on Article 5.1, they also complained about the unlawfulness of their detention in police stations. Again, something to highlight here is the condition of the conditions that unaccompanied minors were held into these police stations. Because under Article 3, the court did find that being held in a police station as a minor can make detainees feel very lonely, and the excessive length of applicants' detention amounted to a violation of Article 3. But what the court actually heard on that occasion is that the children were not able to walk around. There was no court where they could go play or recreate. There was no radio or TV for any communication with the outside world. And this assisted the court to get to the finding that there was a violation of Article 4 for the period of detention within the Dagyavata police station. With regard to the first police station. With regard to the Dagyavata Center, the court held that the center was run by an NGO which has been set up to meet the needs of unaccompanied minors. So the court thought that the conditions there did not exceed the threshold for the seriousness required to a violation of Article 3. In relation to the allegations regarding ill treatment by the police to the minors, the court held that this particular allegation was manifestly ill-founded because the applicants did not substantiate their allegations by appropriate evidence. With regard to Article 3 jointly with Article 13, the court found that there was, due to domestic remedy not being effective, there has been a violation. And of course, in that particular scenario, an appeal to the prosecutor was not found to be an effective remedy because that particular appeal was not possible to order for an effective transfer of these minors to Dagyavata or address their particular complaints for the conditions of their detention. With regard to their complaints under Article 5.1 and 5.4, regarding the applicant's placement in border posts and police stations, the court held that this amounted to a deprivation of liberty. The court held that the Greek provision of Article 118 is not intended for unaccompanied minors, and that Article 5.4 was that there was a violation of this article because the protective custody in police station could last for long periods, which the minors could not be identified by lawyers working for NGOs in order to bring an appeal against this detention. And in particular, because for that particular complaint, the prosecutor had failed to bring the minors in contact with a particular lawyer. The court, in that case, places itself in compliance, in harmony with established case law that the court has concerning irregular migration, highlighting children as vulnerable individuals. The court expands on the lack of measures taken by authorities in establishing, in addition to not taking into account the individual's enhanced vulnerabilities as unaccompanied minors and the principle of the children's best interest. What is most interesting, though, about this case is that the court applies a procedural approach to the provisions of the UNCRC, which encourage domestic authorities to proactively consider whether they act in compliance with their international obligations towards minors, especially considering the best interest of the child in taking any decisions in their consideration. So again, the added vulnerability of the children in that particular scenario comes from their placement in protective custody and the lack of proactivity by the Greek state to consider their international obligations in deciding the best interests of the child. And the best interest of the child is a very, very important provision that we also see in the next case that I have here for you. And it's a case that was very well known because it was one of the most celebrated cases regarding the children in Calais, France. So Khan versus France talks about an applicant, an unaccompanied minor and an Afghan national who had left, like many, his country to seek asylum in Europe, in particular the UK, where he hoped to find protection. So in 2016 February, the prefect of Pas-de-Calais ordered the evacuation and dismantling of the camp for reasons of health, security, and human dignity, as all of you may know. A refugee assisting organization went and found the minor and helped them to apply to the children's judge for an application for provisional care and an appointment for an ad hoc guardians in order to be able to file an asylum application. And both these requests were granted. But despite the judicial orders, when the evacuation plan actually started, in the southern part of the camp, where the applicant was residing, the place where the applicant was staying was demolished. The applicant's cabin was destroyed and no protective accommodation was offered to him. Despite the situation, despite the existing judicial orders, the child welfare services did not place him in care. So expectedly, the applicant complained before the European Court of Human Rights that the authorities failed to comply with the orders to provide provisional care, amounted to a violation of the duty of the state to provide protection under Article 3 of the Convention. And what the court found was very, very welcome was that was a violation of Article 3 due to the degrading treatment that the applicant had gone through, especially considering the applicant's vulnerable status as an unaccompanied minor. And of course, the court there made a note and highlighted that the failure of France to take action in that particular scenario was not convincing, that it was all that France could do at that particular moment to provide protection to that particular individual. This case is very, very important because it brings two issues into perspective. The first one is that it constitutes an important step forward in providing more substantial protection for children in asylum case and encouraging a proactive approach in favor of the state. Secondly, is that the case provides a development in the assessment of best interests of the child in order to provide better protection toward child migration policies and further holds the state accountable, in this case France, for not adhering to their positive obligation and responsibilities towards vulnerable children. And what is interesting to read in this case is that there is a particular point where the court highlights that the French government's claim that usually migrant children do not cooperate in this situation be used as a justification for the lack of action on their side. And the court was very strong in saying that this does not justify not considering the best interests of the child in that particular case in order to provide the protection that is owed to them under their international law and the ECtHR. The next case that I'd like to talk about with you is the case of SF and others versus Bulgaria. And the case of SF and others versus Bulgaria refers to an Iraqi couple and their 3 children who tried to get over to Europe passing through Bulgaria. They were arrested and detained in Bulgaria and complained before the court that the administrative detention where they were placed and the conditions within it amounted to inhuman and degrading treatment in breach of Article 3. The applicants alleged that their placement was contrary also to Article 5.1 and that available remedies were ineffective under Article 5.4. The applicants, also relying on Article 8, complained that their placement in admin detention had infringed the right of respect for family life. With regard to Article 3, to give you a little bit of context, the court reiterated, of course, that following their previous jurisprudence, that there was a violation of Article 3 regarding the administrative detention of foreign nationals. And this was a very good finding because the length of that particular detention was not very long. I've noted here to share with you that according to the allegations of the Bulgarian government, their administrative detention lasted for 32 hours, whereas according to the applicant's lawyer, the administrative detention of the family lasted for 41 hours. But even so, because of the anxiety that was caused to the children, this particular detention was considered to be to reach the threshold to violate Article 3. And this brings into perspective two things that the court considered there. First of all, not looking only after the physical safety of the children in such cases, but also looking about the anxiety and the mental well-being of the children while they are placed in detention. Also, the issue of time is very much highlighted by this case, that if the conditions are severe enough, then one would not have to show as a lengthy exposure to detention conditions in order to be able to reach an Article 3 threshold. With regard to Article 5, and this was another substantive part of that claim, the court found a violation of Articles 5.1 and 5.4 in respect of the children due to the necessity of placing the children in detention which was not of last resort. Again, the court was not persuaded that the domestic authorities had done their best in order to find alternative measures, and that detention for this particular case was indeed a measure of last resort. With regard to Article 8, the court found a violation, and this violation was because of the authorities not taking all the necessary steps to enforce the removal measure as quickly as possible, and thus limit the time spent in detention. And thus, this meant that there was an interference with the right of access with the right of private and family life. Some additional notes about this case is first that this case builds on the protection of children in asylum cases, and the judgment confers that children's extreme vulnerability is the decisive factor and takes precedence over considerations regarding any considerations of their irregular status. And this is something that we have also seen in other cases. So this builds on, it adds another brick in the wall in this protection category. The court noted that material detention conditions in the two detention facilities concerned have been adapting for families and had been kept apart from other detainees and provided with specially fitted rooms and care materials. However, one of the facilities was situated right next to the runways of an airport, so this has exposed the applicants to particularly high noise levels. Again, this is another example where the court has been very thorough and has been looking after not only the physical well-being, so are the children well taken care of in terms of whether they're not exposed to any risks, such as the risk in the first case with children falling out of bed, but also their mental well-being and how their mental well-being is impacted by the anxiety of detention on one hand, and two, the conditions of that detention. So in the other facility, that's something again that has to do with the facts. The family was separated by a net from the other detention center, so there was a lot of noise which added to the applicant's anxiety. So although this was over a very short period of time compared to particularly other cases, the court decided that it has been sufficient to reach the level of severity required to show a violation of Article 3 of the Convention. So this again is a case that I think adds to the protection layers that we have for children. The last case I have here to share with you is the case of Abdullahi Elmi and Awais Abu Bakr versus Malta. So the case, this particular case relates to two Somali asylum-seeking children who applied for asylum shortly after their arrival in Malta. The children were detained for several months while awaiting their age assessment test. And the children complained about the deplorable conditions on their immigration detention in violation of Article 3. The applicants complained that their detention was arbitrary, and they argued that they had no effective remedy to challenge the lawfulness of their detention pursuant to Article 5.4. With regard to Article 3, I'd like to give you a little bit of context of what exactly we mean when we say deplorable detention conditions. There was limited light in the facility where the children were kept and limited ventilation. There were deplorable sanitary facilities. There was no information or support to the children as to their condition and their situation, when they're going to get in, when they're going to get out, and the environment was very violent. These were amongst the allegations that the applicants had submitted. And again, I would like to urge you to look at the facts of this case and the findings for potential parallels that can be drawn between this case and the conditions of detention of minors in other places within Europe. So these children stayed under this deplorable condition for 8 months, which is definitely not a period to be overlooked, much longer than the children that the family detained in previous case. So the court, under Article 3, found that since the applicants were minors who were detained for a period of around 8 months, the cumulative effect of the conditions complained amounted to a degrading treatment in violation of Article 3. This is a very unsurprising finding, but because the conditions were both terrible and lasted for a very long time. With regard to Article 5, the court concluded that the applicant's detention was not in compliance with Article 5.1. Again, that's not surprising. In particular, with regard to the detention complaints, the court said that the detention had a basis in the law, but it was overly severe as a measure because there were delays in the age assessment of the applicant. The court also found that, stated its doubts as to the good faith of the Maltese authorities that made the procedures for age assessment last so long, and that aggravated the duration of the children that had to stay in these deplorable conditions. With regard to Article 5.4, the court found also a violation, as the applicants did not have an effective and speedy remedy under domestic law by which to challenge the lawfulness of their detention. This was yet another case in which the court highlighted one more time that the lack of procedural safeguards with regard to challenging detention conditions or detention makes the case much worse. It also highlighted the importance of the fact that detention has to be considered in the case of children only as a measure of last resort, when no other alternative arrangements can be made. What is most interesting, though, about this case lays not only in the judgment, but also in the concurring opinion, the part that you find after, of Judge Pinto de Albuquerque. And I've put here my favorite parts, because especially the part in red, which I'll read out for you. It says, but the sole fact that the asylum seeker's identity is undetermined or in dispute, or that the basic elements on which the application for asylum, including the circumstances of arrival, are grounded, are not immediately apparent, does not justify detention during the entire status determination procedure. Hence, asylum seekers may not be detained pending a procedure to decide on the right to enter the territory. Judge Pinto de Albuquerque also makes some important comments and a comparison between the standards set in the Grand Chamber case of Saadi and the standards that are required for administrative detention. Notably, the judge says that a detention order for the sole reason of the state bureaucratic convenience equates the targeted people with commodities. The Grand Chamber's interpretation must be reviewed for the sake of bringing coherence to the court's case law and aligning it with international and refugee law. The court cannot remain deaf to the worldwide call that Saadi must go. That is a very, very strong statement, of course, that the judge felt that had to be out there. And this is, I have to say, reflective of a lot of what the civil society feel regarding the standard as set in the Saadi case. The concurring opinion goes on to say that Saadi not only confuses the test of necessity and the test of proportionality, but worse still restricts the proportionality test to a mere arbitrariness case. And the judge also makes references to a growing revolt against Saadi and a spillover effect on Shahal. I found this personally very interesting, and I wanted to share that part with you because I think that the reference to Saadi versus the UK lowers the protection afforded to asylum cases against arbitrary detention, and that if we were to develop additional protection in the future, we have to reform the existing precedent to the extent that it does not conform with present realities. That having said, I have noted here in this slide some conclusions for you. The first one being that we have seen that three main overarching themes that came from the judgments in 2019. First, we have seen the courts embracing international norms, especially with regards to children, the UNCRC. We have seen the court quoting the UNCRC and drawing upon and making links between the UNCRC and the ECtHR, which is a very welcome development. We have seen also the heightened emphasis placed on the assessment and the protection of the best interest of the child. In terms of themes that we've seen in cases, and this is something perhaps that we will have to see also with next year as a follow-up, or if there is a re-emergence of other cases. First of all, we have seen the court talking about the prohibition of children in detention centers due to the very nature of the vulnerability and the inappropriate environments of detention centers for children, so children in detention. Secondly, the link between children and their parents being used by states as a way to keep children in detention, but at the same time, the court highlighting that it should not be used unless as an absolute last resort for the benefit of the interests of the child. And the last important thing that we have seen is that the utmost protection of unaccompanied and separated children is an absolute protection regardless of the migrant route of the child and where they seek to apply for asylum. In other words, the vulnerability of the child should take precedence compared to a consideration of their irregular migratory status. Now, before I conclude, and I'm aware I have 4 more minutes, I have noted for you some upcoming issues and pending cases. For your interest, these are cases that are not open for intervention at the moment, but we're waiting the judgment from the court. First, I've noted here the case of Darbo and Camara versus Italy, and this was a case regarding age assessment and reception conditions for unaccompanied minors into Italian hotspots. And this was a case where the unaccompanied minors were placed in reception for an amount of time in reception facilities together with adults. So we are very much looking forward to see what the court will say about this case and whether the impact of that case and the impact the case may have to other hotspots around Europe. The second case I have for you is Totopa versus Spain, and that's a case about an applicant, and the applicant is a person from Côte d'Ivoire who sent her son with his aunt to reach protection in Europe. The applicant was rescued with his aunt, but were separated. And when they reached, in any event, Spain, the applicant applied for family reunification with the applicant, and this was denied. So there were complaints for Article 8 and 13. I think this is a particularly interesting case because it raises issue of family reunification as well within a context of search and rescue and separated children from family members. Extremely interesting novel, and we're very much looking forward to what the court will say in that. Trovali versus Italy, it raises issue regarding the inadequacy of reception conditions in Italy. That may amount to detention, depending on what the court says, and it has to do with the placement of minors in hotspots in Italy. Then we have the case of Alech and others versus Greece. Again, a very interesting case that came up recently, and the case pertains to the detention of a group of very vulnerable individuals, very much fitted to the theme of this presentation. So it included persons that were victims of torture, persons from the LGBTQIA+ group, and minors placed in very detention cage-like conditions within the Moria hotspot of Greece. We are very much looking forward to see what the court will say regarding the conditions in Moria. This is something very much awaited for. The last case I have noted for you is the case of MA versus Poland, and it's the case of rejection of Chechen asylum seekers with minor children at the Polish border, their prevention of their attempt for asylum, and complaints under Article 3 and Article 4, Protocol 4, while Rule 39 measures have been granted. So with this in mind, I do hope I have given you a good idea of what the court's jurisprudence looked like in 2019 as regards vulnerable individuals, with particular focus on unaccompanied children and children in general. I have placed here the links to the judgments referred to in this presentation for your convenience, and I am very much looking forward to your questions. Thank you very much for your attention.